Of this program station does not
on Wealth with Gary Quackenbush is sponsored by the Word on Wealth Radio Network. This is the Word on Wealth with Gary Quackenbush of GQ Law. Gary is a San Diego financial solutions attorney, protecting people like you. The Word on Wealth team of financial experts is here to answer your questions and help preserve your family's financial future. Now,
you're live.
Happy Monday, everybody. So good to have you along here on the Word on Wealth. Today is the day we are going to have our tax attorney, Rich Mathurin, come on the second half of the show. You'll be able to ask him some questions because we'll open up lines live when he comes on. The agenda for the rest of the week, tomorrow or Tuesday, we've got mortgages. Wednesday, we've got real estate professional, Ken Pecos. Thursday, Anthony Wright, financial matters of all kinds. And then on Friday, we have our Finding Joy Fridays, which is so awesome. Love to have you along. Glad you're listening throughout the week, off and on. And we are here 5 days a week, Monday through Friday, same time, same station. We're here. We're heard on 4 different channels throughout San Diego, California, San Diego. Oh, we get out into the desert a little bit, but online we are available all over the place. If you want to hear our podcast, go to The Word on Wealth. Just look on any of your favorite podcast platforms, whether it's going to be Google or Spotify, or go right to the website itself, which is kprz.com or even kcbq.com, and it will take you to the podcast. So you can look for that. And what the podcast does, it converts this radio show, which we are doing live, it converts it to a podcast. So that means it's just kind of cataloged in order of date and topic, and you can look up and re-listen to shows if you'd like it. Okay, fun topics today. If you want to talk to me on the air and ask me a question, that would be awesome. 888-344-1170, 888-344-1170. I wanted to go over a holographic will. It came up again in my practice. And with a will, we tend to think of the will being kind of the end all do all estate plan instrument. And people will tell me, I say, well, do you have an estate plan? They said, yeah, we have a will. Okay. And then tell me about your will. Well, my house is in my will and they describe it like that. And I go, you mean a trust, like a living trust? Yeah. And it's not like, oh, there's a difference. It's like, yeah, that's what I mean. That's my will. I mean, I guess technically from a kind of a theory standpoint, it is your will, small w, because it's your desires. It's what what you want to have done after your death, but it's not your last will and testament. So I wanted to talk about holographic will and what is the deal with a will? Because there's like a will, which we're talking last will and testament, right? And generically we call it a will. Then you have your last will and testament that could be in a number of different forms. You could have a written will that's, written and witnessed by 2 individuals who are not listed in the will or related to, by blood or marriage, and, 2 independent witnesses that declare that you're of sound mind and over the age of 18, and then they sign it and they do it under the penalty of perjury. That's one type of will. That's kind of the best type of will. Then there's this thing called a statutory will, which is more specific. You can go look up the California Probate Code, look up statutory will, and it'll tell you these are the things that need to be in a will by under statute, which is the laws, the governing body. The statute will tell you what things you need to have in what we call a statutory will. Okay, and then you have a holographic will. And holographic, it's not hologram, although someday maybe we'll have a hologram wills. That would be super creepy. Somebody, it's in a hologram and it's after they've passed away and it says, hello, children, I am your father and here's what I want done. They do that in Star Wars, but not legally in California yet. All right, so holographic. And holographic is a different animal. A holographic will means that the person that did the will, which we call them the testator, because they did a testament, that they did this will holographically, which means they wrote it by hand. They just wrote it all out. And then they signed it with the same basic pen. So it's all done by that person. There was nobody writing for them. There's nobody moving their fingers. The presumption is that, it was done, while they're of sound mind. There's kind of a presumption of that you can prove or disprove. But the idea of the holographic will is it's all done in the hand of the person that did the will. And it is not witnessed. You don't have witnessed holographic wills, because if a holographic will is witnessed, then you have the witness there that, that means there was somebody there while they're writing it up. And that makes it so maybe it's not holographic. Maybe it's not their own thoughts. Maybe the witness was there pushing them to do something. I don't know. But with holographic wills, you just don't find witnesses. All right. So we had a case a very long time ago, and it was when I was doing the estate planning law practice that I do still now. And it was very interesting, where we had a case that we were in probate of a will. It was just a will. It wasn't a statutory will. It was technically a will that was drafted, put together by an attorney. Oh, my goodness. Okay, so it's put together. It was all typed up, and it was witnessed and everything like that. And the will gave the money to a person. Okay. So then what happened is it was a will, and there was property, and there was assets of over, back then it was over 150,000. And so that pushed it into probate court. So we had to file a probate court petition, and we had to notify any family members of the person. And this person didn't have very many family members. So we notified, who we had to notify. Then the probate petition gets put in the local newspaper to notify the public that this will is, being admitted to probate, and that somebody's requesting that this will be administered according to the statutes and the laws under the California Probate Code. Okay. So what happens after you file that is you get a hearing, and the hearing is supposed to come up within about 30 to 60 days. And at that hearing, you're trying to get the petitioner is trying to get appointed as the administrator of the estate. So if it's a will, you'd be asking to be the executor of the estate. Okay. So as the executor of the estate, you'd be asking to be able to administer the estate, all the stuff that's going on, figure out what money there is and who gets it and all that. So while we're in probate, we got my person appointed as the administrator of the estate, which is what we wanted to do. But right before anything happened, we got a petition filed in the probate court that was trying to kick out our will. Now, I'm going to tell you about that coming up next. So hold your breath on that. If you want to talk to me directly, call my phone number at my office. It's 855-500-TRUST, and we can talk about holographic wills. We can do an estate plan for you, fix the one you've got, update it, whatever, 855-500-TRUST. Okay, so we're going to continue the holographic will and what happened in that case right up next.
You've got questions. We've got answers. This is the Word on Wealth with Gary Quackenbush of GQ Law. Gary's here to give you peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. GQLaw.com.
You're saving and investing for the future, and that's good. Have you ever stopped to think, where does my money actually go? This is faith-based investing with Anthony Wright.
Most Christian families don't understand this one thing. The money that you're saving for retirement helps fund the abortion industry as well as other liberal anti-family causes. It's the sad, dirty little secret of American investing world. And here's the good news, though. You probably also didn't know that just a few minutes of your time and we'll screen and clean your investments for you. There's no cost, no obligation. Learn the truth about your own investment mix. Then the choice is yours. Remember, the word says when God's money is in the hands of the righteous, the people rejoice. Well, we also are fiduciary investment advisor representatives. That means that our firm makes a pledge to always act in your best interest. Go to BibleSafeInvesting.com Download a free copy of my book, Faith-Based Investing, or call me at 931-RETIRED. And please don't forget, listen to Faith-Based Investing this weekend right here on Family Talk.
Gary, our listeners are asking about trust disputes and whether or not they'll actually get the inheritance they're expecting.
I think that's a scary thing for most people because they feel like, if I ask my successor trustee, hey, where's my inheritance? You kind of feel like, oh my gosh, I'm being like rude or whatever, inconsiderate. But I'm telling you, if time goes on, if it's been like 60 days, 90 days, 120 days, that's too long to have heard nothing. You're supposed to hear fairly soon, like within a couple of months after someone's passed, you should be hearing from that successor trustee. And if you're not, I think there's an issue we need to address. So it's not like we're going to go screaming in there, filing lawsuits. We kind of use gentle nudges like, hey, do you know what you're doing? Successor trustee, we kind of want to help you do your job, and we help beneficiaries kind of get things straightened out.
Call or click to request your free initial consultation. GQlaw.com, 855-500-TRUST, GQlaw.com.
Of your lifetime. If you're planning to buy or sell a home in San Diego County, do what I do and work with the true San Diego real estate experts. Ken Pecos and the Pecos Group helped me and my family. They can help you. This is Gary Quackenbush of The Word on Wealth. You hear Ken every week here on The Word on Wealth. He's our expert. He's got integrity, exceptional service, deep knowledge of the San Diego, Coronado, and South Bay regions. These are just some of the reasons that Ken Pecos has completed hundreds of transactions. He manages a powerful team of professionals at the Pecos Group. From single-family attached homes to luxury high-value waterfront properties to apartment buildings, Ken Pecos is ready to help you avoid problems and costly mistakes. Learn more online at kenpecos.com. That's Ken Pecos, Pecus.com, or call 619-977-8419.
DRE number 010566969, brokered by eXp Realty.
If you think Ruck is dead,
GQlaw.com.
You're live.
Welcome to The Word on Wealth. This is Gary Quackenbush. Hey, we got Rich Mathurin coming up at the bottom of the hour. So if you want to call and ask questions of our tax attorney, it's going to be 888-344-1170. All right. So I was talking about holographic will before I took a brief pause, and we filed a petition in probate court, and it was not it's a regular will. So we filed in probate court. We were trying to get this guy appointed as the executor of the estate of the deceased person. And into probate court comes another petition. And the petition we call it a competing petition, where under the same person's name, the guy that, oh, there we go. Got to get me back up. The same petition, under the guy that died, a petition came in and it said, actually, we have the will. And the will was not a typed out, it wasn't statutory, it wasn't a typed out will, it wasn't witnessed or anything. It was a paper bag. And on that paper bag, written with felt pen, was dated, and it said, I give everything I own to my good friend, and it named out the person, and it was signed by that person. Okay. So that's what came into the probate court. Well, that's against a will that we had, that there were witnesses, and the witnesses were independent. It was self-proving because the witnesses signed it under the penalty of perjury, that saying that this is what the guy really wanted and he was of sound mind. But the will that we are trying to get to probate court predated the paper bag by probably a year. So the paper bag by date would carry the day and it would win. But the paper bag had to prove that it was valid. So what the paper bag probate petition was saying, this is the guy's handwriting. And then they, the way they do that is with, handwriting samples and, to show that this is his signature. And it became very obvious. I mean, the signature on the paper bag and the signature on the will were virtually identical. So, what do you do? It's like, what? He went through all the trouble of getting a legitimate will prepared professionally and all that stuff. And now he goes and trumps it by doing a paper bag, literally on a lunch bag in his own hand, and signs it and dates it. This is my last will and testament. I want everything in my, so they were able to prove to the court that it was valid. Okay. Now, the challenge that they had doing the holographic will is that we did have a real will that was professionally prepared with witnesses and everything. And the holographic will was giving everything to a friend of his. And the question is whether the friend of his was the one that was camping out at his house as he got older and convincing him that, hey, you should give everything to me. You shouldn't give it to that, that other person. And so the question is whether that he was influenced, okay, improperly. So what we tried to do to defeat the paper bag will was we went and got medical records to figure out what his mental condition was. Did the doctor have any report of dementia? Did the doctor put anything in his notes about, he's not remembering well, or he seems to be, really, he's okay, he's nice, socially he's okay, but he's dysfunctional, onsets of dementia. He's not rational in his decisions. He doesn't know who the president of the United States is. And because they ask specific questions of people to determine whether they really know what's going on. The doctor, it's very important for the doctor as well, for them to determine that their patient that's theirs, authorizing treatment or not, that they're of sound mind. So we looked at medical records to see whether they have sound mind. He was of sound mind. And that's where we were able to show that potentially he was influenced, unfairly influenced by the person that was receiving all the money. And the thing that made it difficult to understand is that he didn't have any children. Okay. He didn't have children. He didn't have a wife. And so he was just giving money to friends. And the concern was, now they all of a sudden switched his friends. Like, what happened there? So our argument, representing the will itself, the real will, was, did this holographic will, was that really his intent? And did he have the capacity to do it? And was he influenced? And that is kind of tough to show because you have to get the records. And we don't have witnesses. That's the very nature of the holographic will, is there are no witnesses. It was very interesting, but that's how probate court works. That's what probate court looks at all the time. And that's what's called a competing petition. Now, it happens sometimes where somebody will do a new will, and it's done all, typed out and, whatever, computerized, and then he signs it, but then, so that will, like, let's say, for example, that's the will that we are kind of put into probate. He didn't have a trust. He just does a will. So this is an example. Okay. I'm making this up, but this is based on stuff I've seen. So example is, a person has a will and he says, I want to give all of my stuff off to the, let's say, to the San Diego Zoo. 100% of my stuff to the San Diego Zoo. Well, his prior will from a year before says that he wanted, half of his stuff to go to his grandchildren, and then the rest of his stuff to go to, the SPCA or something like that. Well, now what happens is the grandchildren would be filing a petition, a competing petition, to say, actually, his real will is this one, where it gives us half of his estate and the other half to the, the SPCA. The new will, where it gives everything to the zoo, doesn't make any sense to us because he wouldn't have forgotten his grandchildren. And so you try to establish there was a relationship with the grandchildren and that that didn't end. It's not like they estranged him or abandoned him, 30 or 40 years before he died, or they never spoke to him, in their lives. It's like you show that these grandchildren had some value, added some value to his life, and they were in contact with him, and, that they spent time and acknowledged that he was their grandpa, and vice versa. So what happens with the competing petitions is that the court's going to have to decide which is the right will. And here's the thing. The judge has to decide which one is the right will. The judge is not going to say, hey, guys, let's split it down the middle. That's called a Solomonic decision, and it can't be done that way. Judges are not allowed to compromise. Judges are saying, okay, on the facts and the evidence that I was presented with and all the proof that was provided at trial and whatever, it's like, this is the correct will. The judge isn't going to say, why don't you split the difference? However, if we don't go all the way to the judge, what each side is weighing out is the ability they're going to have to win their case and provide, like a winning argument. So in this case, both documents seem to be that they would be okay, but there's evidence to show that maybe the second document, the newer will, he was kind of suffering from some dementia. There's some medical reports to show that. And then the old one, it was like, well, that makes more sense because it's going to grandchildren, which they cared about him and, watched over him and stuff like that. And so it's like between the two, if you took both to trial and they would be, going to trial and being tested, which one is going to win? Is the judge going to say it's this one or that one? And you don't want to take that risk. So instead, you go to mediation is one way. And at mediation, all the parties are, typically all the parties are together on each side, and then they know the strengths and weaknesses of their case, and they present that to a mediator. Mediator is like a moderator, a problem solver, somebody that's going to help you guys come to some type of a agreement, understanding, compromise, basically. So the mediator then will go between the parties and try to say, well, if you do take this new will to trial, then it looks like there is some evidence that he was starting to slip, and he also had some, people around him that influenced him a lot. Of course, then the other side of it is the older will, like, well, your case looks, I could understand it. If it weren't for the new will, you guys would win, but there's the new will. So you have a risk. If you go to trial, you may just flat out lose, and all the money's going to go to the new will. So you each have a risk. They each have the risk of going to trial, the risk of spending all kinds of money to get there, spending, $20, $40, $50, $100,000 getting ready for and going to trial. Is that money worth it? Is it really there? And a lot of times what the sides will do is they will just do some type of an agreement, whatever that is, whatever side feels the strongest, we work in agreement. And that doesn't mean we're splitting it down the middle. All that happens a lot of times too, but we're trying to come up with some type of compromise to make each side equally unhappy, because they're not going to be happy. They're only happy if they win. But then if you look at it from a resolution perspective, and maybe, some other type of a relationship, retention standpoint, then you do win. Maybe money-wise, you're not going to win, just going to be some type of compromise. So, people say, oh, we both lost, well, whatever, or you both won. And as long as you feel like you did the best you could in the negotiation and you have this compromise that works out, that's really what you want. Because if you go to trial, depending on how much money is at stake, trial is very expensive. So if you're fighting over a couple $100,000, trial's not going to be worth it, because you're going to spend most of that on your attorneys to get you to trial, because they're not going to go, super easy. They're going to go hard and try to get it so they can win the case. And when both sides do that, you're going to have both sides spending a lot of money, and one side is going to lose. It's just the way it is.
2 minutes.
With negotiation, with mediation, it's just a lot easier because you kind of understand the situation and you are compromising. So a lot of times that's why we do the mediation. And the different types of the settlements and stuff like that. There's mediation, there's arbitration, there's settlement conferences. There's just different things that can be done to resolve it. So to help you remember what's going on, anytime you're in some type of a fight or a battle, which is typically litigation or dispute, we're trying to resolve disputes. The courts have different ways of resolving it. I mean, you could go to mediation, which is very typical. You could actually have the court order you to mediation. Like part of the agreement is, okay, we're going to tell the court that we want the court to issue an order requiring both parties to go to mediation. And then they've got, 3 months to get the mediation done. And if they resolve it, great. If not, then the judge says, okay, that wasn't resolved. Let's move on to trial. And then you set the trial date out, 6 or 8 months from now, and you start getting prepared and all that kind of stuff. So disputes are expensive. Courts are expensive. If you're fighting over, a couple $100,000, I know that's a lot of money. It is a lot of money. But when you're fighting over numbers like that, it's really going to be better to resolve it, unless you really think it's cool to give your attorney most of your inheritance. Is that fair? We're trying to be fair here. All right, this is the Word on Wealth. I'm Gary Quackenbush. 855-500-TRUST is my number. If you want a free trust review to figure out whether your trust complies with the latest California laws and whether it's going to do what you want it to do. What I do with trust reviews is I will go through it and I will figure out what's going on with your trust, and I'll tell you what I think it will do when you die. And if you say, well, that's not what I meant, then maybe we can do an amendment or change. A lot of people do not have trust. Don't feel bad coming in and saying, yeah, I should have got a trust a long time ago because I'm 70 years old. No shoulda stuff here. If you don't have a trust, you got to get one. You're in California. If you have any family or any real property, you got to get one in California. Call me 855-500-TRUST and let me hook you up.
You don't need to know everything. You just need to know where to find answers you can trust when you need them. Welcome to the world.
He even gave you a couple extra seconds.
$500
You're live.
All right. Welcome to the, whoa, here we go. Welcome to the Word on Wealth. Here you are. We got Gary Quackenbush, and we got Rich Mathurin, our tax attorney at GQ Law, the sponsor of this show. If you want to call and ask Rich a question, feel free to do that. It is 888-344-1170 is the number to call. So Rich, welcome to the show.
Great to be here, Gary.
Oops, you got to turn you on here. There we go. Rich's mic is now up to speed. There we go. Okay, that should be better. Now we can actually hear you. Hey, Rich, welcome to the show.
Yeah, well, great to be here. That's one way to shut me out there.
I know, right?
Turn off my mic.
Turn off your mic. Hey, sorry. I can see your mouth moving. Yeah, so we had Rich his mic down. Hopefully that's good enough. So thanks for being on the show. Rich is here with us on Mondays to help us kind of straighten out all the, I don't know. There's just so much crazy stuff that seems like everybody in their anybody that knows anything about tax or whatever, they're hungry for business. And so they're all talking about, these deals you can get, the IRS. I saw one the other day and I was just talking to Rich about it. I literally took screenshots of it because I went, are you kidding me? And I saw these pictures and it was actually on just a regular, program I was on. And what did it say? It was the craziest thing. It was saying, the IRS now has this, sign up today, register here, click here, call us. We'll register you for this program where the IRS will forgive you 99% of your taxes. And I thought, I got to talk to Rich about that because I almost think it's so deceptive, in my opinion, where somebody's saying, yeah, there's this program and you can sign up here. I mean, there's no such program with the IRS. You can't just sign up and say, hey, I want a cancellation of 99% of my debts.
I think they're referring to, I think we've talked about this before, the offer and compromise program. It is a great, great program. Don't get me wrong. It is a super program, but there are conditions to being able to qualify for it. And what you settle with the IRS is not going to be 99 cents on the dollar generally. It is a formula-based application where you have to basically take 80% of the equity in your assets. That would include bank accounts, retirement accounts, equity in vehicles, and equity in your home. So, and plus your net income times 12. And if you can pay for an installment agreement and full pay your balance with an installment agreement, you probably are not going to qualify for an offer. Or if that formula creates a offer that is so high or more than you actually owe, then it really doesn't make sense to apply for the offer and compromise program. So it isn't just something that you automatically qualify for. You do have to go through the steps of the application, and you can't be able to full pay under an installment agreement.
Yeah, there's basically, I mean, it's true. The IRS, what happened is in 2014. So the fact that it's being dubbed as new is hilarious to me because it's, it started in 2014 when the IRS came up with this thing saying, hey, let's do this thing called the Fresh Start Initiative, and we will see if we can collect money. What the government does is every year the government has these numbers, and you can actually look them up. They have these statistics that they say what the tax gap is. What the tax gap is described as, if they collected all the money that was due, they compare that to how much money they've collected. And so they say that's the gap. So every year it's a lot of money. It's like $800 million. So when you see these advertisements saying the IRS has established there's $800 million they want to give to taxpayers, it's kind of a lie because it's the tax gap number, which means that's how much money the IRS could collect if it could collect all of its money. But I don't know, anybody that's listening, it's a small business. Is it even possible to collect all the money that's owed to you? Probably not. It's a big industry, right? So what's happening is the IRS is trying to collect a lot of money. The regular revenues of the IRS every year are in excess of $14 trillion. That's their normal collections of tax returns and, money being paid in through withholdings and estimated payments and all that. It's a lot of money. It's trillions of dollars. But there's this gap of money that if they had collected everything, they would have gotten all, but they would have gotten another $800 million. So there is a lot of money that's outstanding. The IRS tries to figure out ways to close this tax gap and collect more money. So they came up with this Fresh Start Initiative. And it said in 2014, maybe what we should do is kinder, gentler and say, hey, we really would like you to pay your taxes. Would that work out for you? And that didn't go so well, right? The IRS is like, gosh, we just ask for it politely, we don't get the money. So they go through being aggressive and then trying to be kinder and gentler and more understanding. Then they go through the pandemic and all that. So yes, the IRS is trying to collect money. And if we come into the assumption that they're not trying to collect money It's like, are you kidding me? Our national debt is higher than it's ever been in history by a huge, big factor, big multipliers. The IRS needs to collect money. It's the one of only two branches of the government that collects any money net positive. It's the IRS and the DEA. DEA for obvious reasons, but the IRS. So it needs to collect money. That's the bottom line. It has to feed the hungry government, which is fine. So there are deals under the Fresh Start Initiative, and that's what Rich and I are going to talk about a little bit more today. So on this offer, Rich, what you're saying is, as part of this Fresh Start Initiative, the IRS is basically saying, if you can prove to us that if the IRS did all their normal collection channels, if they collect your assets that they could legally take, if they collected the money that they could legally take, if they gave you allowance for certain expenses, the bottom line, you could not afford to pay those taxes off, then that's kind of the basis for this offer in compromise, right? You cannot pay. Even if the IRS took your money involuntarily, you could not pay the tax. That's kind of the starting point for the offer in compromise. So tell us about the criteria. You went through them kind of quick, because I know there's two basic criteria to determine how much the IRS would be willing to accept with an offer in compromise.
I think the first major one is if under an installment agreement, and they have different types of plans based on your balance and when your taxes were owed and assessed, if you can full pay that balance under an installment agreement, they are going to say, no, you can't do an offer in compromise. You need to go into an installment agreement. Second possibility is if you have income and assets that are too high that create an offer that just isn't workable in terms of either it's almost as much as you owe or more than you owe, then again, they're going to push you back into the installment agreement and want you to full pay your balance under that. So,
I mean, that just makes sense. And because we've had people call and say, hey, I talked to so-and-so company and they said that they can do an offer in compromise for me, and they're guaranteeing I can get an offer through. And we've talked to them and said, well, let's just kind of run through things. How much money do you owe? I owe $100,000. Do you own a home? Yes. How much equity is in your home if you sold it today? Oh, probably $200,000 or $300,000. And then I would say, does that make any sense to you that you have $300,000 equity in your home and the IRS is willing to compromise and say, don't worry about it, you don't owe any taxes? And they say, no, but I was told that I could get an offer in compromise. So I think that's where we kind of have to get rid of the tricky part.
Anybody can get an offer in compromise. They'll take your application fee and process your offer, but then they'll keep the application fee, they'll keep the 20% payment down and apply it to your tax balance and reject your offer, or say, yeah, we'll take your offer, but it'll be a full pay offer. So, I mean, if a company says that they're going to put it through an offer without checking about your income and your assets, please run and hide. Those people, they don't have your best interest in heart. You've got to do the analysis and make sure that, one, you qualify and you aren't a full pay candidate under an installment agreement. And two, you don't have all this equity in your assets and income where, it just isn't going to make financial sense to do it.
Yeah, that's so true. And I like to, I mean, we've done, Rich has had some phenomenal success with, offers in compromise. I mean, some where we actually just go like, wow, we never thought that would happen, because it was just, there's so much money owed and the people have income, but it's just like, we've been able to work some really great arrangements. But we're not just trying to bash on other people. It's just, what Rich is saying, and this is to summarize, Rich, is to submit in the kind of in the very, very simplest format, to submit an offer in compromise. You can fill out the form and you can put whatever numbers you want on there. And if you say, I owe $100,000 and I'm willing to pay $20,000, you have to send in a $4,000 deposit plus a filing fee, and you can send it in. But then if the IRS looks at the number and they go, well, you could full pay, they don't send the $20,000 back.
No, they apply it to your balance, and they keep it and apply it to your balance. They keep the application fee, which I think is up to $205 now. Not huge, but not insignificant either. And like I said, they'll send you a nice letter basically saying, you can full pay. So your offer is rejected unless you want to full pay your balance. So
yeah, interesting. So I mean, you can. It's I guess it's not really a lie that you can submit an offer in compromise, but whether they're going to actually accept your offered amount, That's the big thing. So what we're going to talk about next is we're going to go over a little bit more of the criteria. So who should be submitting an offer in compromise, and who are the people that actually get to take advantage of it? And can you convert from an offer to maybe a payment plan? Are there ways to kind of work that? Another thing I want to know, and I don't know if we'll have time, but I want to talk about you, but self-employed people doing offers in compromise, there tends to be a lot more flexibility because of income and expenses and all that. But those are kind of things we're going to be talking about. If you want to get a hold of Rich to talk to him about your tax situation and getting that resolved, the number is 855-500-TRUST, 855-500-TRUST. You can also go to our website, gqlaw.com, gqlaw.com, and you can get a hold of us and get our free stuff on that website. And we'll be back in just a moment.
You've got questions. We've got answers. This is the Word on Wealth with Gary Quackenbush of GQ Law. Gary's here to give you peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. gqlaw.com.
Gary, how do you and your team help our listeners avoid probate?
Well, first of all, probate is a process that involves attorneys, judges, and sometimes contesting parties. And so we try to avoid probate at pretty much all costs. The way we do that is setting up living trusts, setting up properly documented wills, putting the property like houses, cars, bank accounts in that trust so that it avoids probate. Probate is only necessary if the estate plan isn't set up quite right. So we help them get it set up right. And mainly that's done through a properly created living trust.
Call Gary and the team at GQ Law, 855-500-TRUST, or go online and download Gary's free ebooks and videos. Read Gary's blogs, call or click to request your free initial consultation. That's gqlaw.com, 855-500-TRUST.
Request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST. gqlaw.com.
You're live.
Right. We are here with Rich Mathurin of GQ Law. Rich, so good to have you along the show. Let's take some phone calls if you want to call and ask a question about your tax situation. Or if you don't want to talk about yours, talk about a friend's or a family member. It's 888-344-1170. Okay, we were talking about the offering compromise program, which is something we've been like tremendously successful with over, many years. And so I was asking Rich, so Rich, if you were going to tell somebody like, here's kind of the perfect candidate for an offer in compromise, who should be looking to be able to compromise their claim? In other words, not have to full pay, but, make some type of a cash settlement or a cash offer with somebody.
I would say somebody that probably doesn't have any home equity, either doesn't own a home or, is underwater in their home, which is not too many people nowadays, or people that have, I would say a regular low, not a huge income. So, those two people seem to, also people that own small businesses were able to get them their income and expenses can fluctuate. And if we can pick the right period of time to submit the offer, we can generally, get an offer that's reasonable for them. But if you have a lot of high retirement accounts or a lot of home equity, or you're a high wage earner, I would probably recommend going into the installment agreement rather than an offer and compromise.
And so with an offer too, it has to be if you're going to submit an offer, you have to have consistent income. Like if you're on unemployment or you're between jobs, will the IRS, do they want you to submit offers during that period of time?
No, I would recommend what they call the currently not collectible status for that type of individual. If you're on unemployment, that's where you submit your financials to the IRS showing your lack of income and your expenses, and you would have to provide supporting document, bank statements and things of that nature. But the IRS would put you into what we call currently not collectible status. And that is a status that's at a point in time. The IRS, while you're in that currently not collectible, they don't do any involuntary collection activities while you're in there. They can take you out of that currently not collectible if you get a job, win the lottery, etc. But you can stay in that currently not collectible as long as you're unemployed, you're sick or ill or something like that. Also, the statute of limitation on your balances continues to run while you're currently not collectible. So if you have no income, you're not an offer candidate at the current time, but the currently not collectible status is probably the better alternative for you.
So with the currently not collectible, if you are between jobs, and we've seen this too, is like you're between jobs, you just lost your job. The last thing you want to do is call the IRS and you're just going to say, forget it, I'll just let it run. And that's when you kind of get in trouble. So let's say a situation where somebody's lost their job, they're starting to collect unemployment, and they owe the IRS a bunch of money. They had a payment plan. It's now defaulted. So because they can't make the payment, and they just say, just forget it. I'm not making any money anyway. The IRS can't do anything to me. What could the IRS do if you don't have income, but maybe something else?
They could levy your bank accounts. They can put a lien on if you own home. They can put a lien on your assets in the county in which you reside. So they do have a lot of involuntary collection methods if you don't deal with the issue. Again, I think the currently not collectible, instead of burying your head in the sand, go for that currently not collectible status. You do have to show your cards and, provide a financial statement. It's not too complex a financial statement, but, you do have to show what your bank account balances are and what your income and expenses are and provide like 3 months of bank statements. But I think they generally, they understand that if you're unemployed or you're ill or whatever, and you're not working, that you do need a break from collection, and they will, generally grant it if you're, if you what you say actually holds up.
So bottom line is you don't ignore the problem. You just, you deal with it. There's certain things that are available. And if it's currently not collectible, that's going to be some temporary thing. And then as you get reemployed, does the IRS, if you get your job again, does the IRS, do they require you then to call them up and say, hey, I got a new job?
No, they will come to you. I believe they have a right every 2 years to review your status, but also if they get notice that you, via a W-2, a 1099, or a filed tax return, that your income has increased, it may take them a few months to kind of realize that, but they will probably contact you and say, hey, your currently not collectible status is up for review. Please send us an updated financial statement showing, where you stand right now. So like I said, the currently not collectible is a point in time. And if you do have, your circumstances do change and you have the ability to pay, then, they want to push you into an installment agreement. Maybe then an offer is the good alternative. Also, another option that we've talked about in the past, maybe a bankruptcy. If you're sick or you're unemployed, bankruptcy that has income tests, but you certainly, if you're unemployed, you're going to pass the income tests. And there are certain rules for which taxes are dischargeable in a bankruptcy. It's 3 years from when the taxes were due, 2 years from when you actually filed them, and 240 days from when they were assessed. And the return has to have been filed. If they meet all those criteria, you might qualify for a bankruptcy tax discharge, what you call a tax bankruptcy. So that might be an alternative too.
Well, and if you want to find out about the tax bankruptcy, we actually, on our website, which is gqlaw.com, gqlaw.com, there's a book. You can go on there. It's a free PDF. We're doing it through the month of May. We'll go ahead and leave it on there without payment. It's not very long. It's about 25 pages. When you print it out, you don't have to print out the PDF to read it, obviously, but you go onto the website, you click on the book cover. It's actually easy to find. It's orange and it says the tax bankruptcy, picture of a lion on the front, the IRS. And you put in your name and email address, and that will be sent to you in the form of a PDF. And you can learn about a bunch of different things with tax problem solving, and specifically talks about the tax bankruptcy. So pretty cool. And it's available for free on gqlaw.com. And while you're there, you can contact us and look up our blogs and all that other fun stuff that's going on there. So then, Rich, if somebody is, let's say they're self-employed, is it possible for somebody that's self-employed and their income is just kind of up and down, and their expenses are up and down? Is it possible for a self-employed person to also file an offer in compromise?
Yes, definitely. Again, my understanding right now is they're taking a 6-month look back period on your business. So they would average your income over there. And again, you would have to provide 6 months of business bank statements, 3 months of personal bank statements, and all, so you have to qualify under the other, not a large equity in your assets and things like that. Your net income, that would be your business income, that would be attributed to your personal, and then you would be allowed expenses based on your household size. One person would, get a certain amount for housing and utilities, food and clothing, vehicle, medical, things like that. And I'd like to go right up to the line, maybe be a little aggressive on those expenses, but not be so piggish that the IRS is going to say that, this is just too much. And you really, your net income is much higher than what we had reported on the form. But then they're going to take that net income number, multiply it by 12, and then plus your equity and assets. Again, it's about 80% of the equity in your assets. That would be your offer. And I've had maybe I want to think of 5 or 6 recently that were small business owners that we did offers and compromise. A lot of times it was for unpaid payroll taxes,
Okay.
the 940 and 941 what they call the trust fund recovery penalty, where the business taxes were assessed personally to the person. We have discharged we've settled a lot of those taxes through an offer and compromise for small business owners.
And then, so after somebody's gone through an offer and compromise and they paid the deal or whatever, are they still in business? Can they keep running their business?
Absolutely. This is, the offer is about settling the old tax balance. And then, but the one thing that I would recommend, the important thing is you got to stay in compliance going forward. There's a 5-year rule on the offer and compromise. That means you have to file all of your taxes on time for the next 5 years and pay the balances when they're due, or else then the IRS can rescind the offer acceptance and put you back into collections. So
After all that.
yeah, but I've had, one person that worked in the real estate industry that we just did an offer and compromise and settled for him. Another lady that was in the beauty area, settled for her. And it's a huge thing. I mean, we're talking several hundred thousands of taxes for, 5, 10, 20,000. I've had pennies on the dollar. It's not maybe 1 cent on the dollar, but 5, 10 cents on the dollar. That's a pretty good savings.
And Rich is being really modest. We actually had a couple recently we've had a couple where it wasn't even pennies on a dollar. It was fractions of pennies on a dollar. So the IRS, I mean, they are reasonable, but they're not stupid. And there is criteria. And the thing with an offer is, you might think, oh, the form's easy to fill out. I can fill out the form and the budget and whatever. And I can kind of push a little hard on this number here or fudge this number here. But when you do that, if you submit an offer and the IRS rejects it, they won't take another offer from you, because if you submit the forms wrong and you put the wrong numbers on there to try to hide something, the IRS flags you. They say, nope, this person submitted an offer and they didn't tell us about this bank account or this car or whatever, and you're not gonna be able to get an offer. So my point is, and what we have found out at GQ Law is that it's really important to get your offer right. And if it's legal to take a legitimate deduction or an expense, or there's some other things that you could legitimately take, that's why you hire somebody like GQ Law, like Rich Mathurin, to get you the number, the lowest possible offer and compromise that the law will allow. And when you get it done, I mean, clients are just thrilled because it's compromised. It's over. The IRS is over. Yeah, they're going to, watch and make sure you're in compliance for 5 years, but you should be anyway. So if you want to talk about offer and compromise and your other options, give us a call at 855-500-TRUST, 855-500-TRUST. And don't forget to go to gqlaw.com. You can go and read our articles, but get that book, The Tax Bankruptcy. You can share it with your friends, but it's called The Tax Bankruptcy on gqlaw.com. All right, everybody. We'll see you back here tomorrow here on the Word on Wealth. Rich, thanks for being on the air with us today.
Thanks, Gary.
All right. Appreciate it, man. All right. Bye, everybody.
Tell a friend about the Word on Wealth, featured since 1995, with financial solutions attorney Gary Quackenbush, an expert in estate planning, wills and trusts, and tax problem solving. Gary is past president of the California Society of Tax Consultants. Reach out to us. The Word on Wealth team of financial experts is here to answer your questions and help preserve your family's financial future. The information you hear on the Word on Wealth is for general information purposes only. This program discusses general financial and legal topics. Seek legal advice from a competent lawyer for your individual legal needs. The opinion